Good evening, guys. Let's begin. And let me share my screen to you all. Okay. So I hope you all can see my screen. And we are going to start where we left last week. So can you start answering this question number 3? If you all have done, you can share your answers with me so that we can discuss. You got time, you got enough time. So take your time and do it. Can someone respond in the group that we have started the classes? Okay, let's discuss. So in 2010, F, G, and H formed a private limited company. They formed a private limited company. Then F, G, and H Limited. So they have formed a private limited company naming FGH Limited to carry out technical research. So each of them took 100 shares in the company and each of them became a director of a company. So in January 2012, F admitted that she had been working with a much larger rival company. So one of the director is working with a larger rival company, which is IXPLC, and that she had passed on some of FGH research results to IXPLC in return for a substantial payment. So she has exchanged some confidential information of FGH company to IX company. So F maintains that she has done no
Hi,
harm.
sir.
Yes.
Yeah, so I just joined the class. Did I miss anything, sir? Like, what did I miss?
No, you didn't miss. This is the first question we are doing.
Okay,
I
sir.
mean, you would
Okay.
have missed the last class if you have not joined.
Oh,
Okay.
no, no, no. Join the last class. This class I am.
Okay. No, just now I started explaining the thing. I gave a little
Okay,
bit
sir.
of time
Thank you.
for you all to do the question. Okay. So this
Okay,
is
sir.
where I
Thank
started. Okay. No issues. So now, if maintains that she has done no harm, as if GH Limited was not capable of using the information. Nonetheless, G and H are extremely angered by F's actions. So, did you understand the story? So, these are the three directors who have formed FGH company. However, this director is parallelly working with a rival company called IX. Okay. So then he has passed some information of FGH company for in return for a payment. So he has received a substantial payment from that company. Now the questions that they have asked from us, which of which two of the following are consequences to directors who are in breach of their duties to their company? What do you think? What are the consequences when a director is in a breach? What are the consequences you foresee in a company? Payment of a fine to a company, restoration of company's property, repayment of any remuneration paid to the director, or rescission of contract. What should be the answer? What do you all think? Okay, so I have received most of them are saying 1 and 4. Okay, so before I give you the answer, let me mention the consequences to you. So generally, the consequences for directors that are in breach of duties includes few things. The first thing that is including is damages needs to be paid. Okay, so damages payable. To whom they are payable? Payable to the company. Damages payable to the company for any losses. So that's one consequence. The other consequence would be repayment of any profits that you have made. The next consequence is that you need to restore the company property. Restore the company property. And rescission of contract. Now, these are the consequences for a director who are in breach of their duties. So, when a director is in breach of his duty, okay, so when a director is in breach of his duty, he needs to foresee the following things. Now, see, when you know all these 4 points, you know what your answers needs to be. So, it needs to be this one and the last one. Okay. So, make sure you keep a note of this. When there are consequences of directors who are in breach of their duties, these are the consequences that they foresee. They need to repay any losses that company is making. They need to pay it back to the company for any losses. They need to repay any profits if they are making. They need to restore the company's property, and they have to make sure the rescission of the contract. They cease the contract. Okay. Next, the next question. Identify whether F acted in breach of the following duties of a director. So now they are asking whether the director has breached the duties. So the first duty is duty to avoid conflict of duty and personal interest. Has it been breached or not? What do you all say? Has he breached this duty or not? Breach means say yes, not means say no. He has breached this duty. Good. Next duty. Duty to accept benefits from third parties. Has he breached this as well? A yes means the duty is being breached. No means the duty is not being breached. What do you all think? Yes, they have breached both the duties, or he has breached both the duties in this instance. Okay. Then the last one. Identify the type of resolution and the meeting period that G and H would need to use in order to correctly remove F as a director. So now you are going to remove F as a director. So I have told you all, if the decisions are major, you need to go for a special resolution. If the decisions are minor, you need to go for an ordinary resolution. However, in this case, what do you all think? What do you all think? What should be the answer? An ordinary resolution with a special notice or a special resolution with a special notice? The answer needs to be, if you are removing a director, you need to have an ordinary notice or a special notice. You need to have an ordinary resolution with a special notice. Can anyone remember the number of days that they needs to be communicated? It needs to be 28 days. So within 28 days, so you need to form an ordinary resolution with a special notice. So for the directors to remove the other director. So G and H needs to form an ordinary resolution in order to remove F as the director. So to do this, they would have to provide the company with a special notice. So that special notice need to be arranged between 28 days, and you have a general meeting then. You will have call for a general meeting. Okay. So if it's an ordinary resolution, the simple majority would be enough to pass the resolution. Okay, if it's a special resolution, you need the supermajority votes for remove the director. Okay, it's a good question. You can learn few things. So now you need to make sure, do you remember these points? Okay, right. So let's go back to our MCQs again and we'll do the same. I think we completed up to 30 MCQs. So let's start it from 31 and 32. I'll create a poll for y'all so y'all can send your answers there. So I can say question number 30. I didn't receive answers from anyone. If you are attending the question, take your time. No worries. Only from one person I have received the answer. Others? Okay, let's see. Now, which of the following statements concerning the impact of UK's human right is not correct? They are asking for the incorrect one. Legislations must be interpreted in a manner that is compatible with the European Convention on Human Rights. Is that correct? Yes, legislation must be interpreted in a manner which is compatible to the European conventions. So this is a correct statement, but we are looking for an incorrect statement. Okay. New bills must be accompanied with the statement of compatibility with the European Convention on Human Rights? Yes, when you create new bills, when you pass new laws, it needs to be compatible with the European Convention. This is also a correct statement. Then, common law must be interpreted in line with the decisions of the European Court of Human Rights. Yes, the common law must be interpreted in line of it must be interpreted in line with the decisions of European courts of human rights. So the fourth one, obviously it's going to be your answer, but let's see why. The courts may strike out primary legislation that is incompatible with the European Convention on Human Rights. Now, courts can strike out only, not primary, they can strike out secondary. They can strike out secondary, or in other terms, you can also call it as not primary legislations. Okay. So, which are not primary or secondary legislation, the courts may strike it out. But if it is a primary legislation, they can't. They can't strike it out. So that is why option 4 is incorrect. Okay. Right. Now, 32nd one. Let me create another poll for you all. So that's an easy one.
So, um, I have a quick question. So the
Okay.
book I am actually using to study for the law exam, which I'm planning to do at about September end,
Okay.
is from 1st September 2022 to 31st August 2023. Will
You
that
are
book be
referring
valid, sir?
you are referring to Kaplan text.
Yeah.
That book is valid. Don't you have my tudes?
So I haven't actually joined your
My
classes.
okay,
Is
fine.
I did my classes in March 2023 with
Okay, no issues. There are no major impacts, but most of the European convention laws were removed. Correct?
uh,
So all the
yeah,
others going to be the same because if you take the company law, it's the
yeah,
same. But there are few minor amendments in relation to the terms of thresholds. Okay,
yeah,
so those thresholds would vary from the time. Okay, so
yeah,
there is no any major differences. You can refer to that book. It's not an issue. That's all good
yeah.
in when you're studying. But if you want to collect my notes just for a quick
I will.
reference, you can
Yeah,
request it from our admin team. Okay, so if
yeah,
they're
yeah.
in a position to provide you, just drop me a chat. I'll talk to you.
Okay, sir. Okay, sir. Thank you so much.
No worries. Your good name?
Hamna, sir.
Mona. Okay. All right. Liam was convicted of a criminal offense by magistrate court. If Liam has grounds to appeal, which court will case move next? So from magistrate court, so appeals from magistrate court are moving to, it's a criminal offense, right? It needs to move to QBD. What do you mean by QBD? What do you mean by QBD? Queen's Bench Division. So that Queen's Bench Division comes under High Court. So you need to choose High Court. Okay. So they are talking about the appeal. So when they're appealing it, it needs to move to the Queen's Bench Division. So which means it is your High Court. Okay. Right. Then question number 33rd and 34th. You can try till you read and try. I'll create your polls. So this is an easy one. So which of the following describes the liability of a sole trader? So the liability of a sole trader is what? Unlimited. It is not limited by anything. Sole trader, the liability is unlimited. So that's an easy choice, right? But the next one, question number 34. Take your time there and tell me what should be the answer. Guys, at what time the Isha prayers?
So, still the Maghrib Azan hasn't gone.
It's not going right. So anyways, if Isha, you got around 7:40 or 7 something, right?
Yeah.
Give me a second. So, okay, fine. Okay, let's discuss this. The latest accountant of TISA Limited showed that the company had profits available. So the latest accounts of TISA Limited showed the company had profits available for distribution was 10,000 pounds. Mick, the sole director of TISA, negligently misinterpreted the accounts and authorized a dividend payment of 20,000 pounds. Joan, Mick's wife, and the shareholder of TISA Limited saw the accounts and knew saw the accounts and knew the dividend was unlawful. So the other shareholders did not see the accounts. So now they're asking, which of the following parties are liable for this unlawful dividend? So in case of misinterpretation, okay. So generally, directors who misinterpret the accounts will be liable for any unlawful dividend. What did I say? Any directors who misinterpret the accounts will be liable for an unlawful dividend. Okay. However, a relief can be granted if the mistake was honest and reasonable. So, if the mistake is honest and reasonable, you can give them a relief. But in this case, this misinterpretation was due to negligence. This misinterpretation was due to negligence. So, therefore, the people who knew about this unlawful dividend are liable for this situation. So, in this situation, Mick is aware there is an unlawful dividend being paid, and Joan is Mick's wife. She is also aware there is an unlawful dividend. So, other shareholders are not aware. They did not see the accounts. Then they are not liable in this case. Okay, no, this is not a partnership. This is a company. In a partnership, the partners are jointly and severally liable. But in this instance, Mick and Joan are only liable to this situation. Yet again, I'll repeat you some important points. Directors who misinterpret should be liable for any unlawful dividends. Okay? For any unlawful dividends to be distributed, the director who is acting negligently should be, or rather than saying negligently, who the person who is misinterpreting is responsible for that situation. However, a relief can be granted if that misinterpretation was a mistake, uh, is in an honest way or a reasonable way. In that circumstances, you can grant them a relief. However, when it comes to our circumstances, they have negligently misinterpreted this account, and the person who are aware is only Joan and Mick in this situation. The other shareholders are not aware. So the people who are liable for this unlawful dividend is whom? Mick and Joan only. Okay, not
But
if.
sir,
Yes, go ahead.
how can a single shareholder authorize dividends? Like, shouldn't everyone be able to, authorize it? Otherwise, like,
Yeah,
anyone can authorize their
dividend
own
has been
dividend.
authorized. Okay. Now, this dividend has been authorized with in the meeting. However, the amount that has been distributed is mistake. You got it? Now, for an example, you and I and other two are in the director board. So let's assume I'm preparing the accounts. Okay. So I'm preparing the accounts and I'm saying that we have 20,000 pounds for distribution. So will you like to take it up? Of course, yes. You will authorize it. So initially I show it as 10,000 is available, but you are actually misinterpreting it as 20,000. You got it. So
Yeah.
these people will approve it, but they haven't. That's why they are saying that they haven't seen the accounts. So if they have seen the accounts, will they approve it 20,000? Now the last part
No.
I'm saying. Now see, if they have seen the accounts, then they know that for distribution available is 10,000 only, but they haven't seen it. So if they have seen it, they will not approve it. Okay, and this is a private limited company. Okay, it's not a public limited company. So they will have their own articles of associations to distribute their dividends, isn't it? So they can see the main director, and they are saying the Mick is the sole director. You got it? So he is the sole director of this company. So he has made this decision. Okay. So he has made this
Yeah.
decision to distribute dividends. So that's the reason why the other parties are not liable in this situation. Okay.
Okay.
Right. Sometimes the Mick also can escape from this situation if he can prove that his misstatement was reasonable and honest. You got it. So then he also can come out of that negligence. Okay, good. So next one, 35th one. Can you all try it? Think well and answer, because you can easily go wrong here. An administrator of a company has number of powers that may or may not require the permission of the court to exercise. Which of the following is a power that usually requires court approval to exercise? So who is an administrator? So administrator is a person who is trying to save the company and trying to give a reasonable solution to the creditors. So his duty is to save the company, foreseeing whether this company can continue from this situation or not. And also he guarantees the repayment of the creditors. So that is what he will primarily responsible for. However, he has some powers when we appoint a practitioner called as an administrator. So he has a power to appoint a director. He can call meetings of members. He can make payment to a preferential creditor. But if he needs to make a payment to an unsecured creditor, he needs to obtain the court approval. He needs to obtain the court approval. It is really important because unsecured creditors will be settled after the secured creditors. So you know the list, right? So when they will be settled. So if an administrator is making a decision to pay, that situation needs to be approved by courts. So if you technically go through my notes, it is there. Directly, this decision is there itself. Okay, right. 36th one. Try the 36th. Okay, let's see. LT is an accountant who works for T Limited, a company owned by SP. LT has devised a scheme where T Limited can illegally disguise certain revenues so that the company's tax charge is reduced. So it's a situation of what? Tax evasion. You're evading your taxes. Then they are telling that any tax that scheme saves is paid to SP as a dividend. So whatever the tax that you are saving is paid to SP as a dividend. So the question is, which two offenses LT has committed? Which two offenses LT has? First thing is, it is a laundering activity. It is a laundering activity. The other offense that he has committed is failure to report. Who is LT? You are thinking LT is an accountant. So what accountant has missed, or what are the offenses he is committing? So the first thing is he's failing to report. Failure to report is an offense. Also, the other offense is letting TAPA Limited to adhere is laundering activities. They are engaging in laundering activities. So that's a criminal offense. It's a criminal activity.
So why not failure to prevent?
A failure to prevent means he is assisting here. You got it. This is not company is devising it because LT has devised. So is who is LT? The accountant is devising this scheme. So failure to prevent means he has not insist this method at this point. So that is why it can't be failure to prevent.
Correct.
Next question number 37. If multiple choice also. Last question I couldn't make it. Okay, in this poll you can choose multiple answers. Can you hear some background noises?
No, sir.
Okay, let's see. Ian has recently become a father, not a mother. So he's becoming a father for the first time. So he's becoming the father for the first time. Which two of the following are statutory rights that Ian's employer owes him? So when you become a father, a new father is entitled to 2 weeks of paternity leave and pay. You call that leave as what? Paternity leave. Maternity means mother. Paternity means father. So how many weeks? Maximum of 2 weeks and pay after the birth of his child. So what's the first thing? A new father is entitled for 2 weeks of paternity leave and pay after the birth of his child. After the birth of his child. So that's one thing. So I think it needs to be this in this case. And then he is also entitled for 18 weeks of unpaid parental leave. How many weeks? He can go for unpaid parental leave up to 18 weeks until the child is reaching the age of 18. Till the child is reaching the age of 18. And also, another point I would say, he has the right to apply for the flexible working. He has the right to apply for the flexible working, but it does not have to be granted. So here they are telling that right to a change in his terms of employment to allow flexible working. No, if company wills, that's fine. However, he's having the right to apply, but not right to change. So be careful with that. And they're telling that The right to protection from redundancy until child's first birthday, no, there is no rights as such. So technically, you need to remember if you become a father for the first time, so then you are entitled to leave called paternity. So you have the right to statutory paternity leave and pay for a maximum of 2 weeks. And you can go for an unpaid paternity leave up to 18 weeks till your child is reaching the age of 18. Okay. 38th one. We'll discuss it together. It's an easy one. Which of the following will the registrar of companies hold on a company's file? Copies of all ordinary resolutions, certificate of incorporation, minutes from the board of meetings. What do you all say? What do you all think? Registrar of companies will hold on a company's file the certificate of incorporation. Yes, that's correct. So when you send a certificate of incorporation to the company, the registrar will keep a copy on the company's file. Okay, so he will keep a copy. Then you don't want to file all the ordinary resolution. It's not necessary. But copies of board meetings are not sent to the registrar. You are not going to send the copies of board meetings to the registrar. Okay. And copies of all ordinary resolutions? No, you don't send all ordinary resolutions. Right. Next. Do 39. Let's do 39 together. Which of the following reasons is an automatically fair reason for a dismissal? Pregnancy of an employee, taking part in an unofficial industrial action by an employee, capability of an employee. So if someone is taking part in an unofficial industrial action, so that is a fair reason for dismissal. That's a fair reason for dismissal. Capability of an employee can't be a fair reason for a dismissal. Here the question is, they are asking the fair reason for a dismissal. So taking part in an unofficial industrial action, and you can also say it can be a threat to national security, are two automatically fair reasons for a dismissal. So if you take part in an unofficial industrial action and you being a threat to the national security, which means you are automatically dismissed. That's a fair reason. Okay. So pregnancy is an unfair reason. Capability is a potentially fair reason. Okay. So
Sir,
capability is a, yeah,
unofficial industrial action comes under protest, right?
it's an yeah. When it comes to protest, trade unions. Now, when it comes to trade unions, okay. So that's an industrial action that you take. So legal one is fine. An unofficial one is not fine. Okay.
But protests are never legal, yeah.
Now protest. Now see the protest. Why you are protesting? For a reasonable thing. So in the grounds of taking part a reasonable action, for if you are participating for a reasonable action, then that is fine. But if you are striking for an unofficial one, it is not. So for an instance, let's assume suddenly you are going for a trade union and participating. Generally, trade union things are communicated, right? Without communicating, you can't go for a strike. If employees are not working, for an example, let's assume if the employees are not going to work, let's take our railway department, suddenly they are going to go for a strike. They will announce it. Tomorrow we are on strike. Or our teachers in school, they will say for next few weeks, we are going to be in strike. We are not going to teach the students. You got it. So those are some official strikes. But if you participate in something else, that will be considered as an unofficial strike. So the occasions where it is a fair reason for a dismissal, two things. If you are causing a national threat to the national security, and if you're taking part in an unofficial industrial action, are the two occasions where you consider yourself automatically, it is a fair reason for a dismissal. Okay. So here it is a situation where you automatically becomes dismissed. Right.
Correct.
Which two of the following are elements of a company's constitution? They're asking the elements. What do you all think? Elements is articles of association and companies' resolutions. Okay. A company's constitution is what you record in the articles of association and any resolutions or agreements that it makes. So the elements of a company's constitution, they're asking the elements of a company's constitution is articles of association and companies resolutions that you pass. Okay, so understand the question here. The question is about the company's internal constitution. So the internal constitution is formed in the articles of association and companies resolutions. Right. Let's move into the fourth question. Okay. I'll give you all 10 minutes. So it's the time 7. So by 7:10, I will discuss. Have your answers ready. I hope you guys are ready with your answers. 2 years ago, Finn inherited some money and decided to invest the money in company shares. So he's investing in shares. So now, at that time, he heard that H Limited was badly in need of additional capital, and the directors had decided that only way to raise the needed money was to offer fully paid up £1 shares to new members at a discounted price of 60 cents per share. So Finn thought the offer was too good to miss, and he subscribed and paid for 20,000 new shares on this basis. However, H Limited since gone into insolvent liquidation, owing a considerable sum of money to its unsecured creditors. So, with the remaining money of his investment, Finn subscribed 10,000 shares in IPLC, although there were nominally £1 share. He was required to pay £2 for each share he subscribed for. The shares are currently trading at $2.5 per share. Okay, fine. So let's see the first question. Which of the following describes Finn's liability for H Limited's debts? So jointly liable for all companies' debts with the other shareholders, no liability because he has already paid for his shares in full. Liability in full for £8,000, or liable up to £8,000 depending on the H limited owes. What needs to be the answer? What do you all think as the answer? What did you choose as the answer?
Some reasons, I was thinking that, no,
Hmm.
I don't know. I know it's stupid, but then I think that the answer is not in these four choices because 12,000 is the amount he paid.
Mhm.
Uh, so I feel like that is the amount he should be liable for and not 8,000. I'm not very sure, but yeah.
Okay, no worries. Anyone else? Any other comments? Anyone else? Any other comments? No, what did you choose as the answer? Second one. Amruti? Second one. So you all say no liability because he has already paid for his shares in full. Guys, can you all remember something called nominal value of share? What is nominal value of share? Or par value of share in other terms? Nominal or par value?
The share value price that was sold initially, the first price,
Yes, the
one printed on
initial.
the.
Good. So this $1, um, okay, this $1 is the nominal price or the par value. Tell me. Now see, you have to be very careful here. At the time H Limited was badly in need of capital, the directors had decided only to raise the needed money and was to offer fully paid £1 per share to the new members at a discount of 60 cents. So the directors is making a big mistake here. What is the mistake? What is the big mistake? They are discounting, they are discounting the nominal value of the share. They're discounting what? The nominal value of the share. Can they discount the nominal value of the share? They can't discount the nominal value of the share. The market value of the share, they can discount. So by discounting the nominal value of the share, at the moment, you are collecting from your shareholder 20,000 for 20,000 shares, you are collecting only 60 cents. So as you said, it is 12,000. That is fine. However, in the eyes of law, this is an offense. This is an offense. No company can issue shares below the nominal value. So the person will become liable. The person will become liable, okay, to pay up, to pay up the balance. So which means 40 cents. In other ways, I could say 40 cents. So I have purchased 20,000 shares. Of this, 40 cents I need to pay if the company is in a position not to settle their creditors. If the company is not in a position to settle their creditors, I owe this amount as a creditor or as call in arrears to the company. Okay. So in this case, this will become 8,000. So what happens is at this moment is you are liable up to 8,000 depending on the amount H limited owes. Okay, you are liable only up to 8,000, but it will depend on the amount that H limited owes. And also, when you are allocating shares, it is possible for a part payment of for shares to be deferred in future date. So that is what we call it as call in arrears, right? So this will be considered as a part payment. This 12,000 will be considered as a part payment. But now you can have a doubt. No, the company is selling at 60 cents per share. Okay, but when the practitioner comes, when he comes to know at this discount, this is not something valid. So now let's assume if my company shares are my market value of my company shares are $2, then I'm fine. Now, the next question you might have in your head is, so how did you decide it as the nominal value? Have they mentioned the market value? No, right? So then this is assumed to be your nominal value. Okay. So in this event of shares being transferred, the uncapital or the unpaid capital, I would say, will becomes as a debt. It will become a debt to the shareholder. So which means it will be stated as call in arrears in your financial statements. Okay. So Fin will be liable for H limited for any unpaid element. So the unpaid element is the difference between this $1 and this 60 cents. So that is 40 cents. That's why he is forming this 8,000 form of liability. Now it will depend for him to pay. It will depend on him to pay based on the company's liability. Okay, so if company requires to settle the unsecured creditors, now see, as a result of this, it has gone to insolvent liquidation, okay, and owing a considerable sum of money to its creditors. So if company is able, without collecting this 8,000 pounds to settle the unsecured creditors means, fine, you don't want to pay it up. However, if you could not meet the creditors, then you need to make sure you pay up the balance. You pay up the balance. Okay. You can't consider this as a liability, which, I mean, you can't consider it as a full payment for the shares. In very simple terms, I'll explain again. Okay, sure. I'll explain it to you again. Always remember the nominal value of shares. Now I'm issuing shares. My nominal value of share is $10. Let's assume it's $10. But I am selling it to you since I'm having a financial difficulty to raise money. Okay. At $5, let's assume. So when you purchase this at $5 and you have purchased 100 shares from me. So 100 into 5. This will be $500. So you have invested only $500. Technically or legally or officially, you must pay $10 for this. I mean, you must pay $10 for this 500,000 shares. You need to pay how much? $10 for this 500,000. Sorry, my bad. How much shares I told you? 100, no? So for this 100,000 shares, you need to actually pay 10. So business should have collected 1,000 as capital, but instead of raising money 1,000, you have collected 500 because no one is buying your shares. Your company is performing poor. So you have given a discount at your nominal price. Can an organization give a discount at their nominal price? No, they can't. So how now what will happen now when business goes into liquidation? Now let's assume you are going into liquidation. Your business is going to die. So when you are going to liquidation, at the moment of liquidation, your practitioner, okay, your practitioner will decide to settle all the liabilities, right? Now, if the company is in a position where it could not meet their liabilities, then you are becoming liable to the company. Why you are becoming liable to the company? Because technically you should have paid for $10, but you have only paid for $5. So the balance $5 is receivable to the company in accordance to the law, because law says no company can issue shares or discount shares than their nominal value. And also, can you remember in this instance, go to your notes and refer, I would have said the uh, rule of consideration does not apply here. So what does consideration means? Consideration needs to be sufficient, not adequate. But in terms of shares, it is an exclusion. Here, the consideration needs to be adequate rather than being sufficient. So where you become liable to pay this $5. You become liable to pay this $5 per share to the company. Did you understand that or did I confuse you? If you are confused, you can ask me again. I will explain you again. Okay, cool. So then the next one. I PLC must transfer the excess fin paid over the nominal value of shares to a general reserve. So what is the situation? Your nominal value is $1, but you are paying $2. So the extra money, do you transfer it to general reserve or not? Is it true or false? It is false. The extra money you transfer it to share premium. The extra money that you collect from shares, you transfer it where? Not to the general reserve. You transfer it to share premium. Okay. IPLC is not permitted to pay the excess fin paid over the nominal value of the shares as dividend. True or false? Can you issue dividends from share premium? Can you issue? You can't. So this is a true payment. You can only distribute dividends from your retained earnings. Retained earnings is only your distributable profits. From share premium account, you can't use this money to issue dividends. Make sure you know all these things. These are very important things that you need to remember. IPLC is permitted to use the excess fin paid for the nominal value of shares to bonus issue. Can you issue bonus issue using your share premium account? Yes, you can. So from the share premium account, what's the double entry for that? Share capital account credit, share premium account debit. So you can use share premium account to issue a bonus issue. Then IPLC is permitted to repay the excess fin paid over the nominal value of the shares back to him as cash payment. Can they make the back? Can they pay it back the nominal value? No, they can't. So it is a false step. It is a false step. Understood? Any doubts? Any doubts, guys? So I hope you all got it correct. Third point. Third point. Okay, I'll let me explain in this way. Remember, share premium is the excess money that you are collecting by issuing shares. What is share premium? The excess money that you are collecting by issuing shares. So this excess money you collect, what are the situations you can use? You can use this money to issue bonus issue of shares. What is bonus issue of shares? Giving free shares for your existing shareholders. Giving free shares for your existing shareholders. Then you can meet up business startup costs. If business needs any startup costs, and if you need some extra money, you can utilize that. But can you issue the excess money that you're collecting from shares as dividends to pay out dividends? You can't. Okay. So can you make the excess money you collected as a cash payment to the shareholder? No, you can't do it. Is that clear? So in part A, if they don't give an insolvent liquidation situation and ask for the liability, it will be the same. Yes, it will be the same. Even if they didn't ask for the insolvent liquidation position, it will be the same because you need to pay up. By law, it is illegal. Okay. So if you go in terms of law, you will become an illegal transaction. That's an unlawful transaction. Okay. Guys, let's take a small break now and be back in 20 minutes. So now it's 7:30. I'll join you all at 7:50. So once we are back, we got 5 more questions to finish this paper and one last multiple task questions. So let's finish out this paper today. Okay. So let's see which two of the following are criminal offenses that directors of a company may commit as a consequence of their company being insolvent. So if you are, as a result of these two activities, your company is becoming insolvent. One of the main thing is all these situations are consequences or offenses where a director can commit. However, the offenses which makes your company to be insolvent is when you make the declaration of solvency a false statement. That's a criminal offense. And wrongful trading. So I would say it again. All the offenses may be committed by directors. Yes, can be committed by directors. However, making a false declaration of solvency and wrongful trading are the consequences of insolvency. So the consequences of insolvency. Right. 40 seconds. Right. This is an easy one. Which of the following is a remedy for breach of contract involves an injured party claim the value of the work they have done? So that is what? Quantum merit. It's an easy one. What do you mean by action for the price? Action for the price means you are recovering a specific amount. You are recovering a specific amount. You are recovering a specific amount. So generally for the goods that you have supplied. Okay. So what do you mean by specific performance? Specific performance means what? You need to perform the contract as agreed. Specific performance means what? You need to perform the contract as agreed. Rescission means what? Rescission means you are reversing what has happened. You are reversing what has happened and you are putting back to the pre-contract status. So you're putting back everyone back to the position. Putting back everyone into the pre-contract position. What do you mean by pre-contract position? Before we start up the contract, how were you? All those status will be recovered. Okay. Next, 43rd one. That's an easy question. Okay, let's discuss. In relation to the contract law, which of the following statement in relation to acceptance of an offer is correct? Acceptance may be indicated by a person's silence. No. If you are silent, it is not acceptance. Acceptance must be made in verbally. No, it is not a must to be made in verbally. Acceptance may be inferred from a person's action is your answer. Acceptance does not needs to be necessarily be made verbally. Don't guess an answer. You should know the terms and laws behind this. Okay, so we have learned contract law enough times. So make sure you repeat it again. Okay, try the 44th one. Which of the following parties are owed a duty of care by an accountant in respect of accounts that they have produced? So, to whom an accountant is liable for, or who, where he needs to show a duty of care? The client only, the client and any person relying on the accounts, the client and any person that accountant knows they will rely on the accounts needs to be the answer. The client and public at large, no. So as an accountant, he owes a duty of care where accountant knows that the client and any person who will rely on what he has said. So for them, he is owing a duty of care. For them, he is owing a duty of care. Okay, the last one. Try the last one. Right, let's discuss which of two following contracts will intention to create legal relations to be presumed. A contract between a man and his brother in relation to transfer a property between them? Yes, there is a contract in that situation. A contract between two friends for one to wash the other's car. This will be not considered as a having an intention to create any legal relations. Okay, so this is not presumed to be. So this won't be your selection. A contract between a mother and a daughter for the daughter to pay mother's housekeeping on a month on housekeeping money while she lives at home. No, that is a domestic reason. These two are the domestic reasons. A contract between a company and an employee will have an intention to create any legal presumptions. Okay, so these are the two situations. Other two situations are not. Okay, so those are the domestic matters where the intention is not presumed. Right, okay. So we are done with the 45 choice questions. So let's move to the last task question in this paper. Okay, start doing it. Okay, let's discuss. JAS PLC is listed on London Stock Exchange. So Kip works for JAS PLC as an accountant. So Kip is an accountant of JAS PLC. While drawing up annual accounts, Kip noticed that J Company's profits were better than anyone could have expected. Okay. As a consequence of this knowledge, he bought shares. He's buying shares in J before its good results were announced. He made a substantial profit on the share dealing. So Kip also informed his friend about this. So before they were announced. So L also bought shares in Jazz PLC. So which two of the following are elements of the definition of inside information? So what are the elements to be the definition of inside information? I'll give you some points. It needs to be related to securities. Needs to be related to what? Any securities. Then it needs to be specific or precise. Another point is still the information has not made public. So it is not made public. So, and it's likely to have significant effect on securities. Right. So now the question is, which two of the following are elements of the definition of inside information? Everything seems to be, isn't it? Generally, to be an inside information, it needs to be an information which is related to the security. And is that correct? No. So what do you think? I have mentioned everything here. So everything they have given. They are asking us which two of the following are elements of the definition of inside information. The both elements of the definition is being specific or precise and likely to have significant effect on the price of securities will be considered as the elements of will be considered as what? Elements of the definition of inside information. So whatever the factors which I have typed here is in accordance with Criminal Justice Act. Okay, in Criminal Justice Act, this is how it is defined as inside information. So inside information, the two elements of inside information means it is being specific or precise and likely to have significant effect on the price of securities. Okay, that is the elements. Refer to the notes again. And also, whatever the points what they have given here related to security, yes, inside information mean it is related to your securities. These are price sensitive information. These are price sensitive information. and being specific or precise, and the information is not yet made public. So if the information has not yet been announced, if it is not made public, then it's an inside information. It is considered as an inside information. If it has been made public, so in this situation, they are telling that it is made public. So if it has been made public, then it is not an insider information. Then it is likely to give you a significant effect. However, if they ask what are the two elements of the definition, it needs to be specific or precise, and you should have a significant effect on the price of securities. Okay. Then they're asking, identify which of the following offenses Kip and Lou have committed. So Kip is the accountant of the company. He has encouraged another person to deal, isn't it? And he has used the inside information. So he has committed both. However, Lou has only used the trading information. So in this instance, Kip has of activated or has committed both offenses, where Lou has only committed trading use of inside information, which was given by his friend Kip. Okay, right. So that's the end of this tute. Let's move to another mock paper. Okay, and we'll find some other questions. Now, this is one of a specimen paper from an extract of a plant. Okay. Yes. No, that's wrong. So you thought one wrong because of any. No. Of course, it's about securities, right? Okay. Relating to any securities. All right. If you have marked those as incorrect, then I'm happy. If they are related as, if you are trading it as a correct one, then it is not. If you're trading it as a wrong one, yes, it's correct. I didn't read your next comment. Okay. Yeah, it can't be any securities. And things which are made public, it needs to be not made public. See, the definition is not made public and related to securities, not any securities. Yeah, that's the correct thing. So this one and this one is not the answer. So third and fourth one should be the answer. Okay, sorry, second and the fourth one. Okay, guys, let's move to another mock paper. So can you all start answering these three? Right, let's discuss which of the following may imply terms into contracts: statute, third parties, or third parties of the contract. Which of it needs to be statute? Yes, statute will imply terms into the contract. Good. There are a number of ways in which investors can take interest in a company, and such different interests have rights attached to them. Which of the following normally participate in surplus capital? So, in surplus capital, is it preference shares? Is it ordinary shares? Is a debenture secured by a fixed charge, or is it a debenture secured by a floating charge? So generally, you collect surplus capital when you are issuing the ordinary shares. When you are issuing the ordinary shares, it is the situation where you generally or normally collect more capital. That is what you call it as share premium. So in the context of English legal system, which of the following courts only has civil jurisdictions? It's only in county court. So you have jurisdictions. Now these are very easy questions. Okay. So in the context of English legal system, so we deal only civil cases under county court. Okay. Try fourth one, fifth one, and sixth one. See, some questions are very easy. It has been technically repeated. Now, see the fourth one we just discussed in one of the other paper. In the context of employment law, which of the following is an automatically fair grounds to dismiss an employee? So, if you are participating in an unofficial industrial action, then you are automatically getting it. Automatically, it becomes the fair reason for a dismissal. Got it? So it is not redundancy, it is not refusal to join a trade union or legal prohibitions. So the next one, which of the following business forms does the abbreviation limited after the name of business indicate? It needs to be a private limited company. So not very often you will get easy questions like this, but when you get an easy question like this, don't miss it out. So Jazz has been continuously employed for 6 years. How many years? 6 years. Which one of the following states minimum period of notice she is entitled to? So 6 years means he needs to stay there for 6 weeks. How many weeks? 6 weeks. So make sure you refer to the minimum criteria grid. So you have to remember that grid. What does it says? So that could be a revision point for you to go back. So these are some easy questions. That's why I'm brushing it off. Okay. Try the seventh and eighth one. Which of the following is indicated by the abbreviation LTD at the end of the company's name? Where the shares are not transferable, shares are not be offered to the public, the shares are freely transferable in a stock exchange. So in abbreviation, limited means they're talking about a private limited company. So in a private limited company, you can't transfer or you can't offer the shares to the public. You can transfer the shares between the shareholders within the company. It is not transferable. That is incorrect. So shares may not be offered to the public. You can't offer it to the public. Then in section 122, Insolvency Act specifically provides a distinct ground for applying to have a company wound up on the ground that it is just and equitable to do so. So it is fair to wound up the company or wind the company. Which of the following parties may petition to have a company compulsory wound up under that provision? Shareholders of the company, creditors of the company, debenture shareholders of the company, the Secretary of the State. Whom do you think? So the person who may petition to have a compulsory wound up of a company is the shareholders. They can petition. Okay. So it is just an equitable to do in accordance with the Insolvency Act 1986. Okay. More has a significant. Did I give time to go through? Okay. Try these three, 9 to 11. Or shall we answer it together? It is some easy questions. Mo has significant holding in the shares of Nova Limited. He wishes to use his shareholding to remove our from board of directors, but is not sure how to do so. So which of the following must be used to remove a director from the office? So this also we discussed in one of the other question. So if you want to send a director home, you need an ordinary resolution with special notice. And how many days it needs to be? 28 days. Right. A written ordinary resolution requires approval of which of the following? Okay. An ordinary resolution you need more than 50%, okay, of eligible members. You need to get more than 50% of the total voting rights of eligible members. Second one, they are telling that more than 50% of the total voting rights of members actually voting, not actually voting. The requirement is to in a written ordinary resolution for an approval. The requirement is this: you need to have more than 50% of the voting rights of eligible members. Fine. Guys, I'm stopping there for today. Okay, so I'll send you this mock paper across the teams and I'll meet you all in the next class. I feel little low.